Okay. A very warm afternoon to everybody. I'm here to speak about today's speaker, that is Dr. Pulla Bhaskara Mohan. Dr. Pulla Bhaskara Mohan is a former judicial member and head of the Department of Jaipur Bench of National Company Law Tribunal. He is presently practicing as an advocate of High Court for the state of Telangana and also acting as arbitrator and conciliator. He is an AMCOM, FCS, LLM, and PhD in law. Dr. Pulla, during 1995-1998, has served with the Government of India as an additional central government standing counsel in the erstwhile High Court of Andhra Pradesh. Presently, he is the standing counsel for BSNL and Food Corporation of India in the High Court. Dr. Bhaskara Mohan has a rare combination of academics and professional acumen. He has been a part-time lecturer of Postgraduate College of Law, Osmania University since 1991. In the last 32 years, he rendered yeoman services to the educational field as a very competent law teacher and taught several subjects on corporate law. He has got a fusion between courtroom and classroom. He served Osmania University during 2016 and 18 as a member of Board of Studies of Faculty of Law and revised the syllabus for LLB and LLM courses along with other members. He has also convened as governor of the first National Law Exhibition in India during May 2017 at Hyderabad. He is a master trainer for the Institute of Company Secretaries of India in conducting training programs, courses on ADR and arbitration since December 2019. He is also the chief editor of the Arbitration Handbook published by ICSI during January 2022. He has acted as a resource person with the Andhra Pradesh State Legal Services Authority and also the Andhra Pradesh Judicial Academy in conducting training programs for judicial officers, advocates, and other on the law relating to mediation, conciliation, arbitration, and related simulation exercises, and also Section 89 of the Code of Civil Procedure 1908 since August 2006. He has made an outstanding contribution in the area of ADR as a master trainer, and his training has resulted in gaining excellent knowledge on ADR, both in theory and practice. He has been awarded PhD in 1998 for his thesis entitled Prevention of Oppression and Mismanagement under the Companies Act 1956, Problems and Prospects by the Osmania University, Hyderabad. With effect 29 February 2024, he is also the member of the Governing Council of the ICSI International ADR Center. Sir, it's over to you. Sir, please.
Yeah. Thank you very much, sir.
Thank you, sir.
Very good afternoon, one and all, my dear professional colleagues. And thanks for inviting me to share a little of my knowledge with regard to this ADR and then Arbitration and Conciliation Act. In fact, my dear friends, this particular subject is of great professional importance to all the company secretaries, as with their maturity, acumen, and the knowledge on law, the company secretaries can become part and parcel of this ADR mechanism. And then they can become mediators, they can become conciliators. Now conciliation is not there, mediators only, but arbitrators. And then they can guide their institutions. So today's program is designed to go into this particular system of ADR. ADR means Alternative Dispute Resolution Mechanism. And then, what exactly is about this particular arbitration? Friends, prima facie, we take any dispute for resolution to a court of law. That is a traditional way, moving courts of law. So we have to understand first what is the court craft in India. Then we can understand what is alternative dispute resolution mechanism. Starting with dispute. Can anybody say in the communication box, what is the exact meaning of a dispute and what is the starting point of a dispute? Where from it arises? I think this is a webinar so that there won't be eye-to-eye connection. And this is an afternoon session wherein most of the part, there is a little danger also. Normally afternoon sessions I am reluctant, but today I had to accept. The danger is that I heard the famous proverb, a mother will put to sleep one or few children, whereas a speaker can put to speak the whole audience. And then in a particular webinar like this, where afternoon session after a sumptuous lunch, definitely it is a little bit dangerous. So I hope that will save me from that. And then we will be very active on the subject matter till 4 o'clock. Friends, this dispute means a wrangle. Dispute means a wrangle. And then a difference of opinion, a quarrel, which goes into a legal framework for resolution. So, my dear friends, fellow company secretaries, the dispute arises out of either a contractual or non-contractual relationship. This is how we have to start off learning this particular subject matter of ADR. Because it is not necessary that every dispute should arise out of a contract. There could be a possibility of disputes arising even without a contract. Mr. Ratanji, is there any chat box where people can put forth their opinion, or answers when I put a question? Mr. Ratanji? I think. All right. Okay. Prima facie, there is a contract. A contract means expectations and its fulfillment. Suppose there is non-fulfillment, part fulfillment, bad fulfillment, it will result in dispute which have to be resolved by different fora constituted under the law. It's a civil matter, goes to civil court. It's a consumer matter, consumer forum, corporate national company tribunal, and so on and so forth. Suppose there is no dispute, no contract, but still dispute arises. How? The best example at a classical level for intellectuals like you is the example of a intellectual property right, copyright. I don't enter into an agreement with everybody bypasser. But anybody who violates anywhere in the world, I can charge him and I can take him to task. My copyright is so powerful. That is how, without agreement, also dispute can arise. So, how to resolve these disputes? In fact, as back as 1800, 1781, the regular course at that point of time was to go to courts of law. The courts started resolving the dispute by adjudication. But what happened at particular time, at that point of time also, there was docket explosion, problems faced by the people, and accordingly, in 1781, a new method was designed by the court saying that we will refer this matter to outside the court to a independent adjudicator called arbitrator. So arbitration surfaced in India in 1781, sir. That is ADR, alternative dispute resolution. That means alternative to the dispute resolution by the regular courts of law is ADR. Started in India as back as 1781. Then subsequently it was improved in 1787, 1833, then the CPC 1857, 1882. Then it was converted into the Arbitration Act 1940, and subsequently it was further improved and made into the Arbitration and Conciliation Act 1996 with various amendments during 2015 and onwards. Up to, I think, 2020 also, there are amendments. So what we find, my dear friends, this alternative dispute resolution mechanism means something outside the court of law, not through the regular courts. So, the first step in the ADR mechanism was mooted in India as back as 1781. That is with regard to the adjudicatory process. Then, friends, is my PPT visible, Mr. Ratan? Mr. Ratan Kumar? Mr. Ratan Kumar? Mr. Ratan Kumar? Mr. Ratan, is my PPT visible? Okay, I just want to confirm it. Then if I will go on till 4:10 and questions and answers will follow, right? So are the students, I mean, participants are coming, sir, attending? I see. How many are there as of now? Very good. So they are attentively listening. Because there is no active face-to-face communication. So if somebody puts a query, you will communicate that to me, right? Okay. At 4 o'clock, we will see that. So, my dear friends, in 1781, the ADR mechanism was mooted. From the courts, whether we can go for an alternative, and that alternative mechanism for courts found that an adjudicator can be appointed, and that adjudicator could take the role on. So, alternative dispute resolution mechanism basically contains as an alternative to the regular court mechanism, but not as a substitute, either with the judicial heads or by private parties. So you find with the judicial heads mean that was mooted in the year 1987. That was mooted in the year 1987 in the Loc Adalat system under the Legal Services Authorities Act 1987. This ADR mechanism as an alternative, arbitration was there in vogue with the Arbitration and Conciliation Act 1996, prior to that 1940 arbitration. I told you, in 1781 it was introduced. But in a more concrete way, it was introduced in the Legal Services Authorities Act 1987, where ADR system was given a very scientific boost under this particular legislation. Well, friends, what is this Legal Services Authorities Act 1987? This Legal Services Authorities Act provides, number one, free legal aid to a particular class of the society. Two, conducts, every state has a legal services authority, at the central also, and the legal services authority has got branch. Supreme Court, all high courts, all district courts, and various other civil courts and criminal courts also. What is the role played by this particular authority? It has got a member secretary. He supervises the objective of the act. On one hand, it provides legal aid. That is, we are not concerned at the moment. Our subject is ADR. On the other hand, it provides ADR, alternative dispute resolution, that is, as an alternative to the regular court craft, through Loc Adalat system. So the next ADR mechanism is Loc Adalat system. What do you mean by Loc Adalat system, dear friends? This is a little bit tough subject, so I am a little bit slow because I want you to understand it first. The courts from 1781 thought whether we can unload ourselves with the burden. They wanted third-party adjudicators referred to arbitration from 1781 with a particular limit. 1987, a very concrete way legal aid was provided and Loc Adalat system came. What is this Loc Adalat system? This Loc Adalats are constituted right from Supreme Court to the lowest court in the hierarchy with a system of permanent regular Loc Adalats, permanent Loc Adalats, mega Loc Adalats. There are three kinds of Loc Adalats. Permanent Loc Adalats, regular Loc Adalats, permanent Loc Adalats, mega Loc Adalats. What do you mean by first Loc Adalat system? The Loc Adalats are constituted with the judges and from various walks of society as members in order to expedite the process of justice. From 1987 onwards, the Act was brought into force. Any matter pending in the courts of law, the parties want to go for a settlement. They can go for a out-of-court settlement, or the matter can be referred to Loc Adalats. Then the Loc Adalat judges will prevail upon the parties to go for a compromise. Today they are all trained judges. And if they agree, the Loc Adalat will dispose of the case with a compromise and it is not appealable again. So, this is called the regular Loc Adalat system. This is called the regular Loc Adalat system. Then, mega Loc Adalats. Mega Loc Adalats are held twice or thrice in the year on the aegis of the Supreme Court of India. And this is a very effective alternative dispute resolution mechanism. I will share an experience. Suppose a bypass was knocked down by a speeding lorry. The breadwinner of the family died. Breadwinner of the family died. Will the government give any ad hoc relief compensation to the deceased family? No. Suppose there is a bus met with an accident. Government buses. Or the rail, Indian Railways, where the government will give ad hoc relief. Suppose a rail accident takes place in lighter vein, I say, because of election time, ad hoc relief will be given both by the state government and central government and railways also. Possibility is there. But suppose a lorry knocks down a breadwinner of a family on the road, no government will take care of it. So, the victim's family should file a case of compensation under the Motor Vehicles Act before the motor accident claim tribunal, and then contest the matter. Here the Loc Adalats are coming as ADR mechanism and giving succor, relief to the needy. How? I remember when I was studying LLM during, I think, 89, 90, Pune University Postgraduate College of Law, a very prestigious institution, Hyderabad. My college, we the volunteers and the legal service authority conducted for the first time in Hyderabad a mega Loc Adalat. Prior to that date, the concerned chairperson happened to be the judge of the civil court, had meeting with the insurance fellows, personnel or owners, and arrived at each case a package of money. I suppose a person claims 10 lakhs. The insurance, today it is unlimited. Supreme Court has introduced. In those days, it was restricted. Then via media, a compromise arrived, recorded, matter was disposed. Then on the mega Loc Adalat day, the insurance companies come with checks. On that day, over 50,000 cases were decided. And then awards were passed. Matters were settled. And several victims were issued checks on that day. We should take in normal parlance an appeal to High Court and Supreme Court. By the time it was decided, some of the survivors will also die. They won't survive. And what would be the amount, we don't know. High Court may reverse it, Supreme Court may accept it. Or High Court upholds, Supreme Court reverses. So these are all the practical situations wherein, with regard to this type of mega Loc Adalat, today lakhs and lakhs of cases are decided. For India, more than 142 crores population, we require even 4 times more the strength of present judges, and then still disputes won't be speedily disposed of because of various reasons. It has got its own permutations and combinations. So the alternative dispute resolution mechanism through Loc Adalat system brings succor and relief quickly to the needy. This is one of the best options. On that day, in 89, my college premises, several widows received the checks with tears, saying, "We never expected it could be done so." That was the first experience, I remember. Then it was further taken. Today, mega Loc Adalats are held all over India at several places, several times. And several matters are being disposed. Majority of the matters relate to these motor vehicle accident claims. and also the credit cards, efficiency of services in banking system, and so on and so forth. So whatever matters are pending in the civil courts now can go to a regular Loc Adalat or can be closed in mega Loc Adalat, or else they can be closed in the permanent Loc Adalat. What is permanent Loc Adalat, dear brothers and sisters? Permanent Loc Adalats are constituted with a financial ceiling, of course, consisting of the judges and representatives of public utility services. The matters must pertain to only public utility service. What do you mean by public utility, which is not a private utility? Public utility means not necessary to be private, but only government. Any public utility like transport, car, banking, and of course, motor vehicles, specifically there is a provision, so there is no need. Credit cards. For all these things, services are rendered by the learned judges sitting as permanent Loc Adalat, where the judges can adjudicate the matter. The judges can adjudicate the matter. Adjudicate means normally mega or permanent regular Loc Adalat. The Loc Adalats will only record compromise. May educate the people on compromising and then mediation, act as mediators. But it won't pass an adjudicative order. But permanent Loc Adalats will pass a decree, an order, like a decree. It is binding on the part and not appealable also. There is no appeal, only reduced. So these are all the permutations and combinations on the Loc Adalat system. Now, friends, today the 1989 Legal Service Authorities Act is proving to be very much useful to the society, giving relief and succor to the needy, and the Loc Adalats are working extremely well in reducing burden of the courts. For our population, you require lot and lot of Loc Adalats, mediation centers, arbitration, regular courts, because our country has grown as legal conscious country. Our population, if people don't come to court either due to fear of law or love of law, whatever it is. If they don't come to court and then take law into their hands, there will be anarchy in the society. So, especially with a thickly populated country like India, one has to be extremely careful about those things. That is the reason why ADR is being promoted. And pursuant to this particular Loc Adalat under Legal Service Authority Act 1997, a new wave came up in 2022 by amending CPC, introducing section 89(6). 89(6), where the CPC provided 5 elements for settlement, resolution of dispute. One is matters are pending, they may be referred under section 89 CPC by the court to out of court settlement or Loc Adalats, mediation, conciliation, and arbitration. Now, with the advent of the Mediation Act 2023, mediation is gone. With the advent, the mediation is gone. Sorry, conciliation is gone, and mediation has come to stay in place of conciliation. I will explain it in the further program. So this Loc Adalat system was further improved with 2022, wherein 2022 amendments to section 89(c). And then courts started sending the matters to Loc Adalat, headed by judiciary, or to third party help, that is mediation, conciliation, and arbitration. Today in ADR with third party help, mediation and conciliation became one and the same. So now it is mediation as it is called, then ended with the arbitration. Ended with the arbitration. Yeah. I think Mr. Ratanji, you were saying something, I think. I'm receiving a call. Anything you want to say? Mr. Ratan Kumar? Okay. I can go ahead. Can I go ahead, Mr. Ratan Kumar?
Sir.
I received there is a call from you. Anything?
No, sir, I thought you were calling, you wanted to convey something, so I wanted to ask you, is there anything you want to tell?
No. Now I am in the middle of the stream, going on conveying.
That's great, sir. That's great, sir. Thank you.
So, friends, the Loc Adalat system I explained, section 89 CPC 5 elements, where out of court settlement, court will pass a decree. It is also ADR. Now we will concentrate on the ADR mechanism relating to third party help by mediation and arbitration. Now conciliation is not there. Friends, the courts under 89 CPC further improvement. We started in 1781. Then we have come to 1940 Arbitration Act. Then we have come to 1987 Loc Adalat system under Legal Service Authority. Then we have come to 2022. Section 89 CPC. Now we come to subsequently the Mediation Act, and then, of course, 1996, the Arbitration and Conciliation Act, 2002, the Section 89 CPC, and today the ADR mechanism consists of, through the courts where judicial officers are heading, that is the Loc Adalat system. I have already explained. Second one, through third parties where judiciary is not involved. Judges are not involved. Judiciary is not involved. Then it is with third party help. Who are third parties? You and I, but not judiciary. So this third party help is through the process of mediation and arbitration. So today, any dispute arises in your company, my dear friends, company secretaries, you may go to regular courts of law, but it will take a lot of time. About 8 years, 5 to 8 years or more in a civil court, then the appellate court, the High Court, then finally the Supreme Court. You will end up in the Supreme Court finally. By the time it will be 25, 30 years. So, earlier many divorce matters used to be contested. At the age of 30, husband and wife start fighting and end up in Supreme Court by the time they reach each 30 years, 60 years of age. Fit for nothing. Today, wisdom is prevailing. So, people are trying to separate, compromise, and then try to get rid of the nuisance. Times are changing, my dear friends. In the same way, today the alternative dispute resolution mechanism consists of Loc Adalat under the Legal Services Authorities Act or under Section 89 CPC, mediation, out-of-court settlement, reference to Loc Adalat, and of course, arbitration, because conciliation is not there. Arbitration, wherein Loc Adalats are headed by these officers. Mediation and arbitration are taken up and conducted through private parties. There is a difference. Then, third parties, I can call it better third parties rather than private parties. I called it private parties because the government, judiciary is involved in Loc Adalats, whereas in mediation and arbitration, judiciary is not. Conciliation is no more forgettable. Now we have to understand what is mediation, what is arbitration. And how I suggest company secretary to take up this particular subject as one of the additional items of practice, subjects of practice. Now, commercial disputes. Mediation will be very helpful. How this mediation mechanism works out, I will explain. Mediation of pending matters, mediation of pre-litigation cases, mediation of mediation disputes taken directly without involvement of mediation centers. We will take up the first one, mediation centers. In India, every court of law today is attached with a mediation center. Yeah. Under ADR CPC, the court makes a reference to the mediation center. And then, like 89 CPC, there will be a panel of mediators. In fact, in the panel of mediators, chartered accountants, even company secretaries are there. There may be a matter pertaining to shares, debentures. Company secretaries are the best mediators. The mediators are empaneled, drawn from different professionals. And then mediation referred by the court. Every court today, every center is having, including Supreme Court, High Courts, a mediation center. So, this particular mediation center takes up the matter, then the parties will be issued notices, then there will be a qualified mediator appointed to take care of the matter, and he will mediate, try to use his skills. How to mediate, I will tell you later on. If the mediation is successful, he will give a report and terms, then it will be sent to the court to pass a final decree, compromise decree. The mediation fails, he will give a failure report, and the report will be sent to the court along with the file, and the court will continue with the matter. And court will execute regularly. It will take 5 years, 10 years, 50 years. No matter. This is the way the mediation is conducted. Now, second point. Pre-litigation cases. Where a matter is not taken to court, we can go to pre-litigation case to the mediation center, legal service authority. Legal service authority will issue a notice, then refer the matter to mediation. Then the mediator will take over. If he is successful, he can refer it to the Loc Adalat for passing a decree. If it is a failure, he will issue failure report and he will go. This is how the mediation takes place in India. Now the third one is the mediation directly taken. That means you may come to me as a mediator. I will then refer the matter. I will issue notice to the parties, fix up a date. Then I will go on for, I think in one matter, NCLT really appointed me as a mediator. I conducted several days. Another matter, Jaipur bench appointed me as a mediator. I spent every day 10 hours, 3 days, 30 hours. So we should, as mediators, must have the knowledge of the subject matter, technical issues, and then ask the parties to give briefing, and then sit with both the parties. Generally, mediation centers will be very tense. You must have balance of mind and then objectivity. You should not allow the parties to go to the boiling point and then come to a solution. Be corrective as well as suggestive. Actually, how to do mediation? It's a very big subject matter today in India. How to do mediation? The mediator must understand what is the exact crux of the issue. Then try to convince the parties with individual meetings and then combined meetings. Then be suggestive, corrective. Then try to reach a settlement. If the settlement is successful, you file it in the civil court now, because this is direct mediation. And civil court will again pass a decree that will be binding on both the parties. That is the advantage of mediation. Then friends, but mediation is always with third parties. Prima facie, mediation is viewed as facilitating settlement. The measure of conciliation from Arbitration Act. Mediation and conciliation are one and the same. So mediation is not only facilitating settlement, but the settlement being authenticated by the mediator through the court of law. And then first you will try to be successful, then go to the court for stamping, court of law, then a finale, a decree handed over to the parties there. These are all the permutations and combinations of mediation. Today, a lot of literature was developed on mediation, dear friends. And then, forget about all that. What is mostly required is for mediator, high common sense and worldly wisdom. The parties are very much. Mediator also join one of them, then the matter will collapse. Well, friends, I have explained you in ADR mechanism, 1781 arbitration, 1987 Loc Adalat, 1996 arbitration conciliation act. I deal with it now. 2002 section 89 Then the third party is acting as ADR promoters in the form of mediation and arbitration. Mediation and arbitration. Now, my dear friends, we will come to the last part. What is arbitration? What is arbitration? Arbitration is adjudication. Adjudication means deciding on the rights and liabilities of the parties. Deciding on the rights and liabilities of the parties. Where there is a right, there is a remedy. Ubi jus, ibi remedium. A 23-year-old guy has filed a case against his parents in the court of law, stating his parents are trying to monitor his cell phone. He is now minutes, and they must be issued an injunction order. Don't touch your son's cell phone. But they must purchase it and give to him as a gift. But they should not see what is there. Then pocket money. Where there is a right, there is a remedy. I want n number of money as a pocket money. The son says. Can he get a relief from the court of law regarding this claim? Absolutely no. Because he has no right. Once he completes 18 years or a girl gets married, they can be thrown out of the house. So, there is no right here. What is arbitration? Adjudication of rights and liabilities of the parties. It mostly sounds in commercial plane. But sometimes it extends to partition matters, non-commercial also. Then friends, if that is the case, the courtcraft involves deciding on rights and liabilities of the parties. Arbitration also involves rights and liabilities of the parties. Then how is that people can as well go to court of law? Why should they go for arbitration by third person? That third person can be anybody. The reason is arbitration is informal, courtcraft is formal. There are limited timings. And each judge is posted with 150, 200 cases. Arbitration is not. And then the position and situation in courts of law is different from the arbitration. In arbitration, parties can choose their arbitrator, parties can choose their timings, parties can choose their judges, place, procedure. Parties are given absolute freedom in arbitration. You cannot say, this particular court I don't want. Whoever judge is there, you had submit. So, basically, arbitration is informal, courtcraft is formal. I will give a small example, friends. In an arbitration proceeding, I appear. The learned justice said he would leave for state so that I may cooperate. I said, fine. Then the following day, we completed pleadings, and then the learned justice started dictating the order. At 5, he started in the evening and closed at 1 o'clock almost. In courts, it won't happen. I got a decree for about 75 lakhs. Something unimaginable. Then he left for state. I left, of course, I took the award and then went to my house at 2 o'clock in the night. My wife asked her, "Kya ho raha ji? Where were you?" I said, why? This is called night arbitration. Night arbitration. Arbitration दिन में चलेगा, सुबह में चलेगा, रात में चलेगा, कभी भी. Depends upon the convenience of parties. Suppose that party says his visa is expiring, he has to go to United States, and the court must hear his matter immediately and pass orders. No question. Not necessary. In similar case, in arbitration, when I was there as a party respondent counsel, the opposite side put the same plea. And the arbitral tribunal said, all right, we will accommodate you. And we used to sit up to 10 o'clock in the night, evenings, regularly, then completed the proceedings. So, arbitration is informal, courtcraft is formal. Now, friends, one more advantage. The arbitration awards are executable globally, whereas a foreign court judgment is not binding in India. In the same way, Indian court judgment is also not binding on foreign courts. But arbitral awards passed in the US, executable in India. Arbitral award passed in India is enforceable in United States. So this is the basic advantage we get in arbitration. And one more thing is, I am of the opinion all commercial disputes could be taken to arbitration, so that court's time will be spared and then usually spent on issues. Then, friends, there is one more aspect with regard to arbitration. As I told you, you can choose your judge, you can choose your timings, and you can choose your procedure. Whether it is courtcraft or arbitration, it is bounded and guided by the meaning of goddess of justice. In fact, goddess of justice is that lady justice with blindfold. You find the pictures everywhere in the world, including Supreme Court of India, but nowhere the meaning is given. with great difficulty I could get the meaning. Say, technology of 16th century. It is iconologia of the 16th century called Caesar Repus. Iconologia of the 16th century. Prior to that, we used to have one Emerald, Lord Emerald as the Samavarti, who has no love, friendship, or hatred. Goddess of Justice is embedded with a dog and serpent, which means that the serpent represents the hatred, dog represents friendship, and a judge or an arbitrator will not have both. He will not have friendship with anybody, he will not have hatred to anybody. So dislikes and likes. He will not have any dislikes, he will not have any likes. Friends, in a particular matter I was arguing, I lost the case to a lawyer in High Court. 15 days later, an arbitration matter, I was appointed as an arbitrator. On behalf of the parties, one party A and lawyer came, another party B and the lawyer who won the case against me came. I immediately declared this goddess of justice following that I lost my case against him and we were opponents. Unanimously, all the four gave in writing, we support you, you go ahead, we have faith in you. Thanks to goddess of justice. I had to be Samavarti. Then I heard the matter, went on for 4 or 5 months. Finally, I favored the case in favor of the lawyer who won the case against me because he deserves under law. Goddess of justice conveys that. So prima facie, arbitrators and judges are supposed to follow this aspect of goddess of justice. And then lawyers must know this in order to guide the courts, assist the courts out. That is the advantage we get in arbitration. Since the awards are executable all over the globe, you can always prefer arbitration as an ADR mechanism with regard to adjudication portion by third parties. So arbitration is adjudication by a third party as chosen by the party, whom they have got a lot of faith. So friends, the ADR and Arbitration and Conciliation Act. ADR in general is embedded in Section 89 CPC today. Arbitration in particular is contained in the Arbitration and Conciliation Act 1996. Underwent drastic changes in 2015. And the mediation part is under the Mediation Act 2023. So CPC 89, Arbitration and Conciliation Act 96, Mediation Act 2023, you will have to study for this alternative. I think you can start pouring questions now. Ratan Kumarji.
Sir, it is the same.
Yeah.
So that link that we have sent you regarding the questions, no, that has all the questions that are coming up.
Where is the link, sir? How to go into the link?
It's in the mail and in the phone both, sir. It's a separate link that I have sent you.
I have to go back now.
Yes, you just open your mail or you just open your phone. It's in the WhatsApp, that link to access all the questions.
It is better that keep like this my laptop and go to the WhatsApp.
Yes, sir, it's easier. You can just open the link there.
1 second. Kindly hold on and help me. This is a separate link to view questions.
Yes, sir. Just the last message that I have given you.
Just wait. Oh, so many questions, huh?
Only the relevant you can take, sir.
Where are the questions? I found the SR number and then participants. 214 participants or download questions.
No, you can just see on the screen also. The first one says, and many times foreign suppliers insist on Singapore, UK arbitration, which is very much expensive vis-a-vis Indian arbitration.
Yes.
But
I'm
taking
coming to that.
monopolistic, yes, sir.
Yes. Where is it? Sir, download questions means I have to click it, right?
Yes, sir. But you can anyway see in the screen itself. You don't need to download.
On the screen itself.
Yes, sir. On the screen, you might be seeing that table in which SR number, membership number, name, email, question.
Yeah.
So beneath that, the list is populated.
Beneath that, in arbitration question of yes. Oh my God, lot of questions. Many times foreign suppliers insist on Singapore. Where I will ask see, madam, this particular Singapore center has become very popular for proximity, accessibility, and for our happiness. On 29th February 2024, our ICSI has started an international ADR center in Noida. And I happen to be one of the governing council members. Sri Sadasivan Justice is the honorable chairperson. And we are coming up in a big way. And we want to make it a very hub for international commercial as well as domestic arbitration. Rome is not built in a day. So it takes time, but definitely I want our ICSI to go in. For pride of ICSI, during December 2019, we started in Hyderabad. I belong to Hyderabad. The first arbitration training program. And we trained as on today over 1,000+ candidates, mostly company secretaries, on arbitration exclusively. And we already conducted several programs. The advanced similar practical training program on arbitration will be held during the last week of June. That is 28th, 29th, 30th June. And the program is fixed. Soon you will get flyer. Most of the candidates who are interested may attend the program, 3 days residential at Hyderabad, and we will give you personalized attention and train you on arbitration. And then we, in fact, issue you a certificate also. And then that would be an advantage for you to know practically how this arbitration is going on. So there will be limited seats. So all the candidates may take best advantage of this. And Singapore Center, that monopoly, we can't help it. We must only work hard to make our center equally popular. That is what is now sought. And all our peers are members there in the committee, governing council, and they're all working hard now. Soon we will receive the, invitation. And then the center is opened already. Excellent building is constructed. And then the empanelment will take place. Rules are being framed. Most probably in a very short time, it will be through. Next question. Other than commercial disputes, a technical one. Yes, arbitration is twofold: technical, commercial, and techno-commercial. So arbitration can be utilized for all the three, in fact, not necessary to be only commercial disputes or technical. Then, a listed company, there is a specific question, entered into arbitration. Due to death of arbitrators and several reasons, the arbitration continued. Again, in the year, other party approaches the company to continue the pending arbitration. In this case, the matter has to be taken to court of law for extension. But definitely the court, if the arbitrators are appointed by the High Court will give extension, or civil courts will give extension. Then the matter will be decided by the civil court. Accordingly, arbitration can be continued. Then somebody asked, sir, when program will start? The program already started. Now we are closing the program. And then over here, but started on YouTube. I don't know. Not able to attend. Somebody said he is not able to attend the webinar. Why? He has to find out what is the reason. And somebody asked, okay. Mostly the questions are when the video will start, webinar will start, video is not clear, like this. And
Sir,
one more.
Sir, you can take the relevant questions that are more about the things, because they might be small queries also, but we'll take the relevant questions.
Yeah, I have given answers for 3 relevant questions. One question again, it does seem having technical problem. No. There is okay. What is the relevance of mediation in IBC matters? Very good question. Ramakrishna Gupta. I think Ramakrishna Gupta ji is practicing company secretary in NCLT, if I am not wrong. Very good question. The mediation in IBC, the answer is very clear. 3-4 cases of IBC were referred to International Mediation and Arbitration Center by none other than the president of NCLT in Hyderabad. Matter is sub judice there. It is pending. And under Companies Act also, mediation now is provided with, and NCLT itself is provided in mediators. I was appointed twice as mediator by NCLT Delhi and Jaipur. Very heavy matters. Companies Act, operation and mismanagement. Mediation is possible. In IBC, also mediation is possible, where they can come to some understanding and closing. This checker of, what you call it, starting of resolution process and then proceeding and then ultimately coming at a later stage. All these CIRP, all these things, appellate proceedings will be dispensed with. So definitely there is relevance of mediation for IBC also. And then the mediation, how it is to be sanctified. The mediation settlement agreement will be filed before the IBC, NCLT. NCLT will pass a final order in terms of the mediation settlement agreement. That is binding on the parties. Because whatever is ultimately the authority says is final. Somebody said we have made settlement agreement through conciliation. What are its consequences as conciliation is no longer in the act? If the conciliation started prior to the Mediation Act, that conciliation settlement agreement is valid. If the conciliation started prior to the Mediation Act, conciliation is valid. Even now, conciliation settlement agreement can be done. After the act was enforced, conciliation is not there. So it is non-est in law, it is invalid. So you have to see when the conciliation commenced, prior to Mediation Act or after. After, no conciliation. Then mediation under 89 CPC is there. Any time limit within time to be completed. Actually, 89 CPC, time limit is not there. A reasonable time. But it is with mediation centers, they are watching and they are closely monitoring. Then somebody said, okay. So any more questions? You can put it, sir.
Sir, somebody has asked when it is not agreed by both parties mutually, what is the next step?
Yes, when mediation is not agreed, if the matter is pending in court, referred by court to mediation, it will go back to the court. Court will continue regular proceedings. If it is a direct mediation, mediation fails, they will take other remedies like arbitration or courtcraft, vagera, vagera, vagera. If it is commercial court, mediation is compulsory. Mediation fails, a failure report has to be filed in commercial court. Only then commercial court will entertain the case. That is under the Commercial Courts Act. So mediation fails, regular procedure will go on, either directly or within the court of law. Yes, sir.
So there is a question saying that in arbitration proceedings, engagement of a qualified advocate is must or non-legal
Not
professionals can
necessary.
also plead the case.
Categorically speaking, any person of age of majority is enough. But we require a matured person. So normally retired judges or advocates are appointed because they have well-versed with courtcraft. They know the procedures well, Evidence Act, and then even formal Evidence Act is not applicable. Definitely, they will have better knowledge. Now we are trying to strengthen the knowledge of the company secretaries. Even though I am a lawyer practicing, but a qualified member of ICSI, a fellow member, I want company secretaries to be trained on arbitration and mediation. Our centers will do that. Already we trained over 1,000 people. So that tomorrow they will become empaneled, eligible to give empaneled, and they will become good mediators and good and arbitrators.
Sir, yes, there is another question saying that what is the procedure for appeal against an arbitration award?
Yes, once the arbitration award is not palatable, under section 34, you can seek, go to civil court to set aside the award. And against that, an appeal lies to High Court under 37. Against that, an SLP lies to the Supreme Court. Yes, sir. Yes, there is one more question. In case of arbitration, timeline is fixed. That is section, yes, 29A. Further, if timeline expires, yes, if the timeline expires, only court can do that. And the court can at that point of time ask the arbitrator to pay back some of the fees or even remove the arbitrator and appoint new arbitrator. So court has multiple powers. That's the reason why arbitrators today must follow timeline. Some question has come why arbitration is not popular in India. Today it is getting popular, and then several arbitration centers came. I started arbitration along with my practice in High Court in 1986. And today there is a sea change. As time passes, it will be further changed. So definitely we have got a positive response to that, and we can be positive on the subject matter. Sir, how much scope is there for recently qualified CS? See, a recently qualified CS must have good experience, and then you must wait for some time to gain maturity. Then he can enter into the field. Otherwise, he must undergo the training and then make out arbitration. So, because you can put a query, a 25-year-old boy or girl becomes a judge as per today's rules, and then he is adjudicating, why can't we be arbitrators? But the judge is given rigorous training. You must also take that rigorous training, then you can. And then failure report mediation need consent of both parties. There is another question. Obviously, the mediator will report failure. Then naturally, he will take consent of both the parties and then he will give a report. Then a contract did not contain arbitration clause. During the course of pendency, both the parties agreed. Can the matter be drawn from the court? Yes. In fact, section 18 in CPC is that only. even originally matter is not slated in arbitration, still, if it is during pendency, the parties can apply. Section 89 CPC, court itself will ask you, and you agree at that point of time. Even otherwise also, at legal notice stage also, you can go for arbitration. There is no need that agreement should contain only arbitration clause necessarily, not necessarily. Yes, sir.
I think it's about time, sir.
Sorry?
I think it's about time we can wrap up this whole session.
Yes, sir. How many totally attended, sir, at the moment?
More than 9,000.
I see. Very well. I am grateful to you and then all my fellow members. I think all are members only, and my gratitude that in the afternoon after lunch session, they made me awaken and then active. And their questions show they are very interested and active, in fact, and responsive to my lecture. That way, I am grateful to all of them. And then sometime again, we'll have an opportunity to meet whenever Mr. RK calls us. So,
Sure,
thank
sir.
you very much.
Sir, we are very thankful for sharing your this time to us and for our members. And I thank you on behalf of ICSI and ICSI International ADR Center for addressing our members and giving them this valuable inputs and all. And we will be looking forward to have more sessions like this with you in times to come. And for everybody who has joined this session, the whole session is available on the YouTube also. So if anybody wants to revisit the sessions, you can go to our YouTube channel of ICSI and get the whole session. Thank you. Thanks a lot, everybody. Have a good day.
Dhanyavad. Good day to one and all. Thank you.
Thank you, sir.
Welcome.
Yes.
Yes. Good day.
Thank you. Thanks to you also.
Namaskar. Namaskar. I am just closing.